Um, Welcome everyone to this webinar presentation of Fur, Feathers, and the Law. My name is Melanie Danielson. I'm a staff attorney with Coast to Coast Legal Aid. In honor of this year's Earth Day, we wanted to put together a foundational animal law course focusing on two major areas. First, the laws that govern the use and treatment of agricultural animals, and second, focusing on a major federal animal protection law, the Endangered Species Act. We have with us today two experts in the field, Erin Okuno and Elise Bennett, who will provide a basic introduction to the topics. Before I formally introduce our panelists, as a housekeeping matter, I do have some questions prepared, but I will hold these questions until the end. Without further ado, our first panelist, Erin Okuno, is an assistant professor of law at Stetson University College of Law in Gulfport, Florida, where she teaches animal law and policy and research and writing courses to JD and international LLM students. She received her JD from Stetson Law and received the Edward D. Foreman Most Distinguished Student Award at graduation. She practiced at a law firm in Tampa, Florida, and then worked for Stetson's Institute for Biodiversity Law and Policy. She also taught as a visiting professor and adjunct professor at several universities. And before joining the faculty at Stetson Law, she was a member of the faculty at the University of Miami School of Law. She is on the editorial advisory board for the Journal of International Wildlife Law and Policy, the faculty advisor for Stetson's Student Animal Legal Defense Fund and Stetson Law Review, as well as a member of the competition committee for the Stetson International Environmental Moot Court Competition. Her research focuses on animal law, environmental law, and international environmental law, particularly the intersection of the First Amendment and agriculture, as well as the rights of nature, wetlands, and endangered species. Our second panelist, Elise Bennett, is the Florida and Caribbean Director and a senior attorney at the public interest environmental nonprofit, the Center for Biological Diversity, where she advocates for endangered species and wild places in the region. Born and raised in Florida, Elise holds a law degree and a certificate of concentration in environmental law from Stetson University College of Law and has a bachelor's degree in environmental science and policy from the University of South Florida. Before joining the center, Elise was a judicial staff attorney in Florida's 13th Judicial Circuit and volunteers her free time working to protect wild landscapes in the Southeast. Thank you to our panelists, and I'll turn it over to Erin.
Thank you so much. All right. Hello, everyone. Thank you so much for giving me the opportunity to speak with you today. Huge shout out to Coast Legal Aid of South Florida, especially Ananda, Jeffrey, Victoria, and Melanie for putting together this program to help people learn more about different types of animal law issues. I am really excited to present today with Elise Bennett, who was one of my closest friends and still is one of my closest friends, but one of my closest friends in law school. So it's fun to get to do this with her today. I am going to talk today focusing specifically about agricultural animals and factory farms. Here is what I am hoping to cover. I'm going to start out with some background on animal agriculture and factory farms, look at some laws that may or may not apply at the federal level, identify a few specific state level laws that focus on agricultural animals, talk about challenges with inspection and enforcement, identify an issue that I'm really personally quite interested in, the constitutional issues with state ag-gag statutes, and then end by talking about some possible paths towards positive change. What does a farm look like? When you're thinking about this, some of you might picture something like this generative AI generated photo on this slide. An idyllic scene with a brightly painted wooden barn. Maybe your barn wasn't red, maybe it was green or yellow or blue, but some happy color. Beautiful grassy pastures, green grass. and happy animals frolicking about. Unfortunately, the reality is far from what some people might imagine. Instead, most factory farms look something like this. They're also known as concentrated animal feeding operations, massive, massive buildings with thousands of animals crammed inside in sometimes very deplorable conditions, and nary a blade of grass or sunlight or fresh air or dirt in sight. Brief background. So, over time, we have seen dramatically fewer small family farms. And instead, nowadays, farms are essentially factories. The animal agriculture industry is big business. The goal is to make money, right? So, to try to produce as much food as possible from the animals at the lowest possible cost. Billions, yes, billions of animals are slaughtered in the United States each year. Arguably, one major benefit of these operations is that they contribute to the food supply, arguably. I'm not sure it's necessary, but that's a different topic for a different day. And of course, they support livelihoods, right? It's business. But they also have significant adverse impacts. They have adverse impacts on animals, the environment, and people. In terms of animals, they are confined, often on concrete floors or in cramped pens or cages in these facilities. They may not be allowed outside at all. They are exposed to unnatural feeding patterns. Sometimes they're deliberately overfed, sometimes they're deliberately underfed. And this is to impact the type of food product that the company is expecting or is going to sell at the end. The lighting patterns are unnatural as well. They're getting little, if any, natural sunlight. They're exposed to sometimes extended periods of artificial light, again, to impact the production of food. They are mutilated in different ways. Sometimes parts of their beaks are cut off, or their toes, their tails may be docked, they're branded. They are given forced injections, sometimes forced impregnation. Not always, but sometimes they are subjected to abuse from the people who work there. And then, if their lives aren't challenging enough, the methods that are meant to end their lives, the slaughter methods, also the whole process can be very stressful, very scary. And sometimes, if they're not adequately rendered insensitive to pain, then it can be painful as well. These factory farms also have negative impacts on the environment, to name just a few: significant amounts of habitat loss, air, water, and soil pollution, decreased sedimentation, greenhouse gas emissions, the list goes on. And then they also have harmful impacts on people. Worker safety is a pretty significant issue in some of these facilities. These types of jobs can be quite dangerous. There are food safety concerns, sometimes related to things like bacterial contamination or foodborne illnesses. There are potential negative health effects like viral outbreaks. And local communities also suffer adverse impacts through odors, pollution, even decreased home values. These are some of the challenges related to terrestrial animal agriculture, not the focus of my presentation, but I will note that aquaculture and fish farming also have some of their own challenges. All right, let's start our discussion of the laws by looking at some of the federal laws that may or may not apply to agricultural animals. The first I'll talk about is the 28-hour law. This statute was originally passed in 1873. The current law was passed in 1994. The 28-hour law regulates, as the name suggests, how long livestock may be confined during interstate transport without unloading them. There are civil penalties for violating the act. The challenge is that it excludes poultry. And in the United States, we slaughter more chickens, more poultry than any other animal. But this particular statute doesn't apply to chickens. It's really fairly narrow in scope. It focuses on interstate transport of livestock. The next federal statute I'll mention is the Humane Methods of Slaughter Act. The original Humane Slaughter Act was passed in 1958 and went into effect in 1960. The current Humane Methods of Slaughter Act was passed in 1978, and that expanded the original act. This statute is administered by the USDA, the U.S. Department of Agriculture. It requires the slaughtering and handling of livestock to be humane. Again, though, chickens are excluded. They're covered under the Poultry Products Inspection Act to an extent, which I'll discuss in a moment, but they're excluded from the Humane Methods of Slaughter Act. This act, again, is fairly narrow in scope. It focuses on slaughter. It does not address transportation or living conditions. So the vast majority of the time the animals spend is their living conditions, and these two statutes that we've discussed so far don't address those. There are two methods or categories of humane slaughter and handling under the Humane Methods of Slaughter Act. The first is rendering the animal insensible to pain, and the second is ritual slaughter, where the animal suffers a loss of consciousness. There are extensive administrative regulations that go into gruesome details about the permissible methods of slaughter. Again, though, it focuses on slaughter only, and the poor chickens are exempt. Speaking of chickens, let's talk about the Poultry Products Inspection Act. This act seeks to protect consumer health and welfare because poultry products are a major part of the U.S. food supply. The focus of the act, though, is on really protecting people, not on animal welfare. But there are regulations, USDA regulations, that do address the slaughter of poultry specifically. And it says that poultry have to be slaughtered, quote, in accordance with good commercial practices in a manner that will result in thorough bleeding of the carcasses and ensure that breathing has stopped prior to scalding. And then let's talk about the Animal Welfare Act. Sounds, again, really promising based on the name. This is administered by the USDA largely through APHIS, the Animal and Plant Health Inspection Service. It was originally passed in 1966 as the Laboratory Animal Welfare Act. It's been amended multiple times. It became the Animal Welfare Act in 1970 and had further significant amendments in the 1980s. It regulates dealers, researchers, and exhibitors. And it sets out requirements for humane care, licensing, registration, marking, record keeping, and reporting. But it excludes farm animals, including livestock and poultry, as well as certain horses. So basically, that guts this law's potential to benefit farm animals. Also, just briefly, there are other environmental laws that are not obviously directed at animals specifically, but animals could, in theory, indirectly benefit from some of these environmental laws. The animal agriculture industry, though, is exempt from significant portions of other environmental laws or is treated differently under other laws, such as under the Clean Water Act. Turning now to state level laws. These are obviously going to vary state to state, and I don't have time to say much about all of them, but I will highlight a few points and give a few examples. States have anti-cruelty statutes, but agricultural animals or husbandry practices are often exempt. There have, however, been efforts in some states to address agricultural animal welfare in very specific contexts. I'll give three examples. Florida has an interesting, rather unique provision in the state constitution. It went into effect in 2008. It's known as the Pregnant Pig Amendment. And as I mentioned, agriculture is typically largely exempt from anti-cruelty laws at the state level, but Floridians voted to include a provision in the state constitution to address gestation crates, to limit cruel confinement of pigs during pregnancy. So you cannot tether or confine the mother pig in a way that prevents her from turning around. There are, of course, certain exemptions for things like veterinary care. And written into the provision is that it's a first-degree misdemeanor for violating it. Another state example from a ballot initiative comes from California. Proposition 12, the Farm Animal Confinement Initiative, was passed in 2018. Y'all may have heard about this one in the news over the years. It's been litigated fairly extensively. This particular initiative prohibited the sale in California of certain agricultural animal products if the animals were cruelly confined, and it set out space requirements. And then another example from Michigan from 2019. Michigan has a cage-free egg law that prohibits the sale of eggs from hens that are confined in a way that does not follow the law's cage-free requirements. So they have to be free to roam, cannot be tethered all day. There need to be enrichments to encourage natural behaviors. And the big one, right, you can't use battery cages for them. Inspection and enforcement face significant challenges and limitations when it comes to factory farms. The agencies that have the authority to inspect these facilities are typically understaffed, so they have very few people who have the authority or responsibility to inspect so many facilities. They're often underfunded, and as a result, or at least partially as a result of the lack of staff and funding, the laws go unenforced or underenforced. And even to the extent that they are enforced, the penalties of the fines don't always seem to serve the necessary punitive or deterrent effect. They're just sort of become the cost of doing business for some of these facilities. And then this is an issue that I've mentioned I have a strong personal interest in. Some of my scholarship has focused on this. Talking about constitutional issues, focusing specifically on the First Amendment and ag-gag statutes. People tend to lack information about factory farms and big ag. The industry sort of benefits from this sort of veil of secrecy. And so for many, many years, decades, probably actually even more than 100 years, people have tried to expose conditions in different facilities through undercover investigations. And so activists, journalists, researchers, organizations, individuals, they try to access factory farms and then try to share photos or videos or audio recordings to educate the public about the conditions and report potential legal violations. In response, some states passed what are known as ag-gag statutes or ag-gag laws. The idea is that they're trying to prevent people from being able to access the facilities. There are different ways that they do this. Sometimes the statutes will prevent someone from lying to get a job at the factory farm to gain access to it. They might prevent someone from accessing the factory farm in other ways through deception, might prohibit photography and audio or video recordings, or might require people to turn over audio and video recordings to the authorities right away. There are penalties that range from possible jail time, criminal or civil fines, monetary damages, restitution. So pretty substantial potential penalties for violating these. Proponents in favor of these laws argue that the laws help protect their property, their privacy, and their business. Opponents against these laws argue that they are effectively anti-whistleblower statutes that prevent people from learning more about what happens in these facilities, and that these statutes, in some instances, may be violating the right to free speech under the First Amendment. So there have been lawsuits filed, often focusing on challenges under the First Amendment. This has led to mixed results in the litigation over the years. Some courts have upheld state ag-gag laws in full or in part, but others have struck them down in full or in part. And there's this challenging tension between First Amendment free speech rights on one hand and privacy and property rights on the other. So this is a thorny issue. There also is an additional wrinkle when the action that the person engages in involves false speech, lying. I do not have time, obviously, to get into the details, but if you'd like to learn more about this, I recently published an article on this topic. I put the information about it here. There's lots of other really interesting, great scholarship on this issue, and if you want to reach out to me offline after the presentation, I'm also happy to nerd out more about this. So with all of that in mind, in terms of some of the challenges and limitations when it comes to agricultural animals and the law, I thought maybe we could talk on a positive note about some of the paths toward legal and policy change. This is not an exhaustive list, but this is just meant to highlight some possibilities. Elise, who you'll hear from in a moment, has experience in a different context with quite a few of these, I'm sure. The first I'll mention, right, is litigation, so filing lawsuits or otherwise participating in lawsuits. Another would be lobbying lawmakers. This might be at the state level or the federal level. If a state has a ballot initiative process, engaging in that. Reporting potential violations and requesting agency or law enforcement. Participating in public meetings about these issues, commenting on proposed rules. Education is important too. Just working to help people understand more about these issues so that they can make better informed decisions. Media also is going to play a significant role in shaping societal attitudes on these issues, which can then, in turn, potentially influence law and policy efforts. Collaboration, I think, is key. So, joining an organization, volunteering with an organization, just working with others, financially supporting the efforts of others who are working on these issues. And then we already have power that we sometimes forget about. We can make choices as consumers that impact this industry. So the choices we make in terms of which products we do or do not buy, that can lead to change within a company because it could potentially impact the financial bottom line. There are many others. Sometimes companies will agree to comply with voluntary standards or guidelines that provide better animal welfare standards for agricultural animals. Sometimes they do this so that they can get certifications that will be displayed on the products that they sell. There are lots of other advocacy efforts you could engage in as well, publishing on these types of topics. And I encourage people, be creative, think outside the box, and just think about how you can help to open up the barn doors and improve the well-being of the animals in these facilities. I think we're going to take all questions at the end. I'm also, as I mentioned earlier, happy to speak with any of you if you'd like to reach out to me after you watch the presentation. Thank you again for your time. I've really enjoyed participating in this, and I'm looking forward to Elise's presentation.
All right. Thank you so much, Erin, for that presentation. I'm really looking forward to following up on the other side of the barn doors, speaking a little bit about wildlife out in their native habitats. But first, I just wanted to extend my deepest thanks to Coast Legal Aid of South Florida, and of course to my dear friend, Professor Okuno, for this opportunity to talk a little bit about the laws we can use to save life on Earth. And as an attorney at the Center for Biological Diversity, I thought it might be helpful to start with my organization's perspective. At the center, our staff and our members believe that biodiversity has intrinsic value and that species have an inherent right to exist. We also believe that the welfare of human beings is deeply linked to nature and to the existence of a vast diversity of wild animals and plants, and that losing even one of those species impoverishes society as a whole. And so that's what motivates us to work to secure a future for all species, great and small, who are hovering on the brink of extinction. And the way we do that is we use science and law and creative media with a clear focus on protecting the lands, waters, and climate that species need to survive. And so with that, we're off. And there is a lot of work to do. And that is because humanity is causing widespread negative impacts on the systems that all living beings, wildlife and humans alike, need to survive. And we could talk about this for an entire presentation, but just a few points to drive home is that habitat destruction is the main driver of species declines and extinctions globally, as well as here in the United States and in the state of Florida. It is considered the main threat for 85% of all endangered plant and animal species. And it's a historic and ongoing threat. It includes both direct killing and harm to living creatures, but also indirect impacts from urbanization, like getting hit by cars or getting eaten by human-supported predators like raccoons, or being genetically isolated as populations are split up by roads and buildings. And then, of course, urbanization also hampers many natural processes like fire that are needed to maintain many ecosystems, especially here in Florida. And because of threats like habitat destruction, pollution, overfishing, poaching, disease, all of these impacts work together to put more than 1 million species on track for extinction in the coming decades. So I hate to start with a bleak picture, but I hope to give you some hope as we go through this presentation and talk a little bit about one of the strongest laws we have here in the United States for defending species from extinction. We're so fortunate that the importance of biodiversity was in the forefront, excuse me. We're so fortunate that the importance of biodiversity was in the forefront of legislators' minds when Congress drafted the Endangered Species Act, which was passed into law and signed by President Nixon in 1973. More than 50 years ago, Congress had already observed that species were being rendered extinct as a consequence of economic growth and development untempered by adequate concern and conservation. And so they created a law whose purpose is to provide a means whereby ecosystems that endangered and threatened species depend can be conserved, and to provide a program for the conservation of each of those individual species. In an often cited Supreme Court case, Tennessee Valley Authority versus Hill, the Supreme Court explained that Congress intended endangered species to be afforded the highest of priorities and set forth a goal to halt and reverse the trend towards extinction, whatever the cost, because the value of endangered species was incalculable. And I'd say that's still true today when we see that the way that the Act functions and the way that the public supports it. Indeed, the Endangered Species Act is our strongest law for species facing extinction. And so while there are many tools that I use on a day-to-day basis to defend wildlife, we're going to focus on the Endangered Species Act today. The Endangered Species Act is wildly successful, and that's borne out in the numbers. The Act has prevented the extinction of 99% of species under its care, and researchers have documented a 90% recovery rate in more than 100 species throughout the United States. The Act has also protected millions of acres of what's called critical habitat, which are areas that are crucial for a species' survival and recovery. And these protections are key. As you know now, the greatest threat to these species is habitat loss. And finally, we know with some research that has been done that an estimated 227 species would have likely gone extinct since the law's passage in 1973, were it not for these landmark foundational protections. So hopefully you're feeling a little bit better about our fight against extinction right now. And we'll build ourselves up a little bit more with two success stories. Most people under the age of 40 are amazed to learn that bald eagles were once in danger of extinction because of habitat destruction and illegal shooting and insecticide contamination. But after receiving the protections of the Endangered Species Act, the bald eagle was actually recovered and delisted in 2007, though it's still protected under the Bald and Golden Eagle Protection Act. Likewise, the American alligator, although it had survived for 200 million years before it was placed in danger of extinction in the 1950s by habitat destruction and market hunting, it became a success story as well. It was recovered and delisted in 1987, so it was actually one of the first few success stories. And there are more recent recovery stories in Florida as well. Two species found here, the Okaloosa darter, a small fish, and the wood stork have been recently removed from the endangered species list due to recovery. Though unfortunately, our wood stork populations here in Florida still have a ways to go. Overall, their numbers are doing much better. So let's dig a little bit into the act itself. The Endangered Species Act is so successful because it provides a whole host of tools informed by the best available science to conserve species facing extinction. And I want to note that while I'm going to focus on how the Act applies to wildlife in the wild, there are also requirements for endangered and threatened species that are held in captivity. I'm not going to speak about those today, but if you're interested, you can go take a look at the Act, and there are many wonderful secondary sources to review as well. So we'll start at the very beginning. For a species to receive protection under the Endangered Species Act, it must first be added to a list of endangered and threatened species. This is known as the listing process. And the Act defines an endangered species as one that is in danger of extinction throughout all or a significant portion of its range. And a threatened species is one that is likely to become endangered in the foreseeable future throughout all or a significant portion of its range. And this decision should be based solely on the basis of the best scientific and commercial data available. This is known as the best available science standard. So this law is administered by the U.S. Fish and Wildlife Service for terrestrial and aquatic species and the National Marine Fisheries Service for marine species. And those two agencies will be looking at 5 factors to decide whether a species meets the definition of endangered or threatened. They'll look at habitat destruction, overutilization, disease or predation, the inadequacy of existing regulatory mechanisms, and a catch-all, other natural or man-made factors affecting a species' continued existence. And that catch-all is where we often see the agencies consider threats like climate change, pollution, or just the inherent vulnerability of very small fragmented populations. And because species facing extinction don't have long to wait around, the law sets mandatory decision-making timelines. It should take roughly 2 years to list a species that warrants protection under the Act. Though I'll note, if you look at that little lizard in the bottom center, the Florida Keys moleskink, it's got that little pink tail. That species has been waiting 16 years for protection now. So the Act is not always working the way it was intended. The Florida Keys moleskink was petitioned for protection by a member of the public in 2010. It was denied protections in 2017. And then my organization, the Center for Biological Diversity, went to court and overturned that decision. Then the agency proposed to protect the species in 2022, and now the agency has promised to finalize those protections this July. So it's just a reminder that there is still more work to be done on implementing this law in a way that effectively and quickly provides protections for species that are at risk. And the Florida Keys moleskink truly is. It lives only in the Florida Keys, and it lives along the coasts, which are highly vulnerable to sea level rise. 2 other aspects of Endangered Species Act Section 4 that I wanted to quickly touch on are critical habitat protections. The Act requires that species have their critical habitat protected, and that is defined as areas that are essential to the conservation of the species, and it can include areas that are occupied by the species as well as unoccupied areas. We know through studies that species with designated critical habitat are more than twice as likely to have improving population trends than species without it. So this is a really important aspect of Endangered Species Act protection. And Section 4 also requires recovery planning. We like to think of this as the blueprint for recovery, and it contains objective and measurable criteria to know when a species is no longer in need of protection. And it also provides a whole fulsome list of actions that need to be taken, everything from reining in overharvest to protecting habitat. It's really the guidebook for making sure we can guide a species from risk of extinction all the way to recovery. Next, we'll move on to Endangered Species Act Section 7. This largely applies to our federal agencies and is often considered the heart of the Endangered Species Act. And I've broken this down into 3 aspects I'd like to highlight. The first one is that the Act actually affirmatively requires federal agencies to use their authorities in furtherance of the Endangered Species Act. That's every federal agency, not just the wildlife agencies. and they are required under the Act to carry out programs for the conservation of endangered and threatened species. Federal agencies are also required to consult with the expert wildlife agencies, the U.S. Fish and Wildlife Service and the National Marine Fisheries Service, to ensure that their actions aren't going to send species farther towards extinction. And the Act sets two very specific requirements for these federal agencies. One is procedural, and it's that all federal agencies must consult with the expert agencies, and there is a whole consultation process that's carried out between the expert agency and the federal agency that may be taking some kind of action that may affect a species. And the other requirement is substantive. Every federal agency must also ensure that it will not jeopardize a species' survival and recovery or destroy or adversely modify that critical habitat that we talked about earlier. And as this consultation process moves forward, it is also done on the basis of the best available science, the same standard that you see in the listing process. And this process not only offers an opportunity for the agencies to understand the consequences of their action and to mitigate harm to species, but it also presents an inflection point, an opportunity to reflect before taking an action that could hurt a species' chances of recovery or even doom it to extinction. And you'll see on this slide here, I have one example. It was a proposed water park in Miami-Dade County a few years ago. It was being carried out by the county and some private individuals, as well as the National Park Service. And it would have destroyed and degraded habitat for several endangered species, including the Florida bonneted bat, that's the bat there on the top, and the Miami tiger beetle. The Miami tiger beetle is so endangered that we only know of two populations in existence, and they're both in Miami-Dade County. One of them right in the footprint of this project. You can see that red outline there, and that project overlaps and is directly adjacent to really important habitat for the bat, the beetle, and several endangered and threatened plants. Unfortunately, the federal agency that was involved with this project failed to fulfill its consultation obligations, and so environmental organizations filed a federal lawsuit, and the court set aside the decision to pursue the project. And it was at this inflection point that all of the agencies and the individuals involved determined that they ultimately didn't want to pursue this project in this location, that the value of the endangered species in the area were more important. And so, not only are there firm requirements that are enforceable under the law, but it also has really important soft influence in making sure that we're thoughtful about the way that we impact our wild neighbors. One final aspect of consultation that I wanted to note too is a requirement to reinitiate consultation. Whenever there's ongoing federal involvement or control over a project, agencies are actually required to check in with the wildlife agencies again in certain situations, including if the number of species impacted by the project ends up being higher than they anticipated, or if new information reveals impacts or effects of the action that hadn't been previously considered, or if the action is modified in some way that hadn't been considered before. And also, if a new species is listed under the Endangered Species Act or new habitat is protected. And lastly, I'll just note that these really strong protections that apply to federal actions always apply, and only in exceptional circumstances can federal agencies avoid the consultation requirement. In that case, the Act sets forth a detailed process that involves convening what's known as the Endangered Species Committee, or also known as God Squad, because they're basically playing God, deciding whether or not a species, can be impacted in a way that may affect its existence. This process has only been convened 4 times in the history of the Act, so it's an exceptional circumstance where you might see this exception applied. Next, this may be the most familiar aspect of the Endangered Species Act for people is Section 9, which prohibits various activities with respect to endangered and threatened species, import, export, transport, possession, sale, but probably the most well-known one is the prohibition of take, without authorization from wildlife officials. And take is defined by statute to include harming, harassing, pursuing, hunting, shooting, wounding, killing, trapping, capturing, collecting, or attempting to engage in any of those activities. The act also prohibits attempting or soliciting someone else to carry out those activities. I also added plants on here, although I know we're focusing on animals today because the definition of take and the prohibitions are a little bit different. For plants, in addition, there's a prohibition of removing, damaging, or destroying plants on federal land, or removing, damaging, or destroying them anywhere else if it's in violation of a state regulation or a trespass law. Um, so here you can see examples of two species that are protected from take. On the top, you have the sand skink, which I know it looks like a snake, but it has tiny little legs. You can just barely see them if you really squint your eyes. They're known for swimming through the sands of our upland ecosystems in the center of the state along the Lake Wales Ridge. And then below is the Florida bristle fern, as found across large portions, well, some portions of South Florida. So now that we've talked about the prohibition against take when it's unauthorized, we can talk a little bit about the fact that sometimes take is authorized under the Endangered Species Act, and that is done through permitting. The act allows the take of species in several limited circumstances, including for scientific research, for enhancement of survival, and for incidental take. That's when someone's undertaking an activity that's likely to harm or kill a species, but that's not the primary purpose. Like building a housing development in a place where a species is present. The goal isn't to eradicate the species from the area, but it happens as a result of undertaking that activity. And in those cases, any person, whether they're a private individual or a government agency, must apply to get a permit, and they have to create a detailed habitat conservation plan that aims to avoid, minimize, and mitigate the harm to the species to the greatest extent practicable. Um, Beyond that, before a permit can be issued, the Fish and Wildlife Service or the National Marine Fisheries Service must find that the taking will not appreciably reduce the likelihood of survival and recovery of the species in the wild. So there's sort of a backstop to make sure that the impacts can't be so bad that you're going to drive a species out of existence. And then the service will also set permit conditions that must be met, otherwise, the permit can be revoked. And these permits can be sought on a one-off basis where a private party seeks permits on their own for individual activities, but it can also be done on a larger scale, like Charlotte County has done in creating a habitat conservation plan for the threatened Florida scrub jay, which you can see pictured here on this slide. The county, in authorizing development, realized that it was impacting the Florida scrub jay and decided to come up with this comprehensive habitat conservation plan to ensure that its development decision making wasn't driving the species towards extinction. And finally, Endangered Species Act Section 11 talks a little bit about penalties and enforcement and citizen suits. So I'll just briefly note that penalties can be pretty severe for violating the Endangered Species Act. Violators can face civil penalties up to $25,000, criminal fines up to $50,000, and even imprisonment for up to a year for certain violations. Enforcement can be carried out by the federal government, but it can also be carried out through citizen suits. The act empowers any person to bring a lawsuit in federal court to enforce the act against any other person, including the government when it breaks the law. And this safety net ensures that the requirements of the act are followed. So how this works is any person may file a suit in federal district court in the judicial district where the violation has occurred after giving 60 days notice to the violators and to the wildlife agency that they intend to proceed. If after those 60 days, the person violating the law has not fixed the violation, then you can proceed. And if a private individual prevails, they can also seek and receive reasonable attorney's fees and costs where appropriate, which seems only right if somebody is upholding the public interest in protecting endangered species. And while there continue to be legislative efforts to weaken the statute itself, I also wanted to point out that they have largely failed. And this is likely in part because the American people are strongly in support of protecting endangered species, and the Endangered Species Act itself is also popular in its own right. One survey of studies over the last 30 years found that support for the act has remained high as 84%. And that spans across political stripes, where you live in the country, the urban-rural divide. It's really, I think, heartwarming to know that one thing that we can all agree on is that we don't want to drive species to extinction. So, as you're considering ways to advocate for wildlife or saving life on Earth, it's worth considering the legal tools under the Endangered Species Act. And if you want to reach farther, I would urge you to consider supporting groups that are defending endangered species and the landmark laws that protect them, and also to be an environmental voter, because in the years ahead, it's going to be critically important that we continue to have these tools to protect the beautiful places and the incredible creatures that make living life on Earth so special. So with that, I will turn it back over so that we can jointly answer some questions. It's been a real pleasure, and I am so grateful for the time you've taken to be with us today.
Well, oh, sorry. Thank you, Elise and Erin. This was really great. Obviously, these laws and these topics are really nuanced and very complicated. So thank you for giving us an overview of these topics. So I'll get right into some questions. I'll start off with some of the agricultural laws that we learned about. One second. Let's see. And feel free, each of you can answer if you have anything to add. But the first question for Erin is, why do you think agricultural animals are treated so differently under these laws?
There are probably a lot of reasons. When we think about animal law broadly, or really any area of the law, the beings or entities or people, animals that we decide to protect to a greater extent or to a lesser extent often is going to be driven by societal values at the time. It also will be driven by regional, so geographical area. And so if you look sort of comparatively country to country, the way that we treat our agricultural animals might be shocking to other countries. Whereas they might be surprised by how we sort of protect and revere our domesticated animals. So I think part of it is where you live, part of it's cultural, part of it's societal. So that's kind of one bucket of influence in that space. I think the other horse in the room, if you will, is that agricultural animals have a lot of economical value to organizations and people in our country. And so because they are, like I said, I would argue this point, but because they are arguably considered an important part of our food supply, they have it's big business. And so those interests have deep pockets and have the ability to lobby and influence laws one way or the other. And I think because of that, it has resulted over time in weaker regulation, lack of regulation, exemptions, exceptions that apply in the context of animals in the agricultural industry. I'm sure there are lots of other reasons, right? Historical reasons as well, but sort of money and the way people feel about the animals definitely plays a part in the differential treatment of farm animals.
If so, you mentioned a couple of federal laws that relate to the slaughtering, the methods of slaughter, transportation, but there was, like you mentioned, kind of a lack of laws relating to the actual living conditions, especially because the animal welfare law excludes a lot of these agricultural animals. So, if you wanted to improve regulations or improve the quality of the living conditions, what kind of regulations would you want to see, or do you think would be helpful in improving their living conditions?
This is a hard one for me to answer because I don't really think that I personally, this is my personal view, right? Don't think that they should be in this position in the first place. I don't think we should be
Mhm.
exploiting animals for food or other purposes. But that aside, I don't know exactly what that kind of statute or series of regulations would look like, but I think as a starting place, right, we could look to perhaps including them in anti-cruelty statutes instead of exempting them or exempting the animal husbandry practices from provisions that are within state anti-cruelty statutes. So that could be a starting place. That would be challenging because there's going to be an inherent tension between the fact that we are ultimately keeping these animals in captivity to kill them, and the fact that we're trying to apply an anti-cruelty law to those practices and to those animals. So that would be a challenging fit, but I think that could be a starting place. But as you noted, Melanie, one of the gaps I identified is the living conditions themselves, and that's the majority of their life here on Earth is the time they're actually in the facilities. And so if there were interest in improving those conditions. And we've seen this, right? We've seen this in small ways over time. Different states have picked particular issues specifically related to confinement in many instances and decided that they need to at least be able to move around and exhibit some natural behaviors. Could we go much further with that? Certainly. But I do hope that we will continue to see more of those types of initiatives at the state level that will improve different aspects of their living conditions if there's not sufficient interest or appetite for a wholesale change in those conditions.
And I'm not sure if you mentioned this in your presentation, but what are the types of litigation that you see or tend to come up in relation to factory farms? Like, what's the biggest or most common type of arguments or claims that are brought?
I don't have data to suggest like what the most common types. I'm sure someone has done research on this, and I would love to see it. The one that I have spent the most time researching for scholarship purposes and my own personal interest is looking on the constitutional side of things, in the ag-gag context, like I mentioned. So there's been significant litigation in that space, sort of one step removed, but still impacting agricultural facilities is a series of lawsuits related to tag gag laws, which relates to the labeling of these of animal plant-based alternatives to animal products, animal food products. But that's the one that I've looked into the most personally is the constitutional side of things. And when it comes to getting information about the facilities, the type of claim that my research I've looked at most is under the First Amendment specifically. But there are a variety of claims, sort of ongoing litigation with the dormant commerce clause. There's a variety of different claims that can come up in this space.
And we learned a little bit about citizen suits with Elise under the Endangered Species Acts. Who has standing to bring claims in factory farm related practices, issues, and what does that look like? Who can citizens bring claims in this area?
That's the problem is we are really reliant on the agencies to enforce the few laws that are on the books and the few provisions that do apply to the agricultural industry. For the most part, it's incumbent on the agencies to act. And as I mentioned, it's one of the significant challenges. And right, and this is not necessarily a political issue. It's not, I think, based on any sort of like ill intentions. It's just that the number of people they have to address issues compared to the number of facilities that they have to cover is not feasible. And so because they don't have enough people, they don't have enough funding, it's really difficult to enforce the provisions that are in place in a meaningful way that actually encourages or incentivizes compliance with the acts.
Very interesting. Definitely a place for advocacy going forward or changes in the law. I'm going to switch now to focus on the Endangered Species Act. So, Elise, you told us about how successful the Endangered Species Act has been in helping endangered species thrive again. And then you told us a little bit about an endemic Florida species that is still waiting to be listed as an endangered species. So, what is the biggest challenge to getting listed?
Yeah, what's really fascinating is the act itself is so strong, and really where we see the trouble is how it's administered. The upside, because we have the citizen suit provision, is that we can enforce the law, but it takes time. And so even for a species like the Florida Keys mole skink, which my organization petitioned and has filed several lawsuits to keep moving through the process, it's taken us, more than 15 years. Meanwhile, sea level rise is already swallowing up many areas of habitat where the lizard still lives. And so, I think one of the most important things that we as citizens can do is to push for more support, funding, and staffing to carry out the Endangered Species Act requirements.
So you also mentioned another section of the act that requires the consultation process. How often do agencies fail to engage in consultation, and how long does that process take? Tell us more about that process.
Yeah. So I could have spent hours probably detailing the process, so I didn't, but it is a very detailed process. I would say the majority of the time, in normal circumstances, agencies do undertake that consultation. It's pretty rare to see a situation where they just entirely bypass it. In the case of that water park project, in fact, I think the agency just, the folks working in that agency department didn't realize they needed to do it. And so, but there are also willful attempts by agencies to bypass it. And again, that's why we have the citizen suit provision. But when the consultation requirement is complied with, what that looks like is an agency creating a biological assessment, which is a document that looks at what species are present in the area and may be affected by the project. And they look not just in the footprint of the project, but also at impacts that might extend beyond the footprint. So, for an example, if you have a project that has bright lights that extend for miles around, even if the footprint is only an acre or two, the agency will actually look to impacts well beyond. And that's really important for nocturnal species like the Florida bonneted bat or the Florida panther. Um, so they'll look at all of those impacts and then they'll determine whether it's likely to adversely affect a species or not likely to adversely affect, or they might find there's no impact at all. And then they send that assessment to the Wildlife Agency. And as I mentioned, for terrestrial and aquatic species, that's Fish and Wildlife Service. So we'll use them as an example. The service will then look at that assessment and decide whether they concur with that finding. If it's findings of no impact or not likely to adversely affect, the agency may say, okay, you're going to undertake some mitigation plans that you've created and you can go ahead and move forward. If the project's likely to adversely affect, then there's a formal consultation process that ends in something called a biological opinion that's issued by the Wildlife Agency, and that it specifies how many species will be taken by the project. And then it also sets forth all kinds of conditions and requirements. If the project is likely to jeopardize a species' existence or to destroy critical habitat, the Wildlife Agency will also recommend alternatives. Reasonable and prudent alternatives is the text of the statute, and that's to avoid jeopardizing a species' very existence. But at the end of the day, for federal agencies, what they get is that biological opinion, and that provides them a defense to take liability, so they won't be violating Section 9. But it also sets forth a lot of conditions and requirements to make sure that species in the area, although some may be taken or harmed or killed, that overall the species can continue to exist.
So we talked a little bit about some of the litigation in the citizen suits. What is the role of the courts in interpreting the act and kind of enforcing the act?
So that has recently changed. For a long time, under the Chevron case, the courts would largely defer to reasonable agency interpretations of statute. But now, under the Loper-Bright decision, it's up to the courts to determine what the best reading of the act is. And so it's been really fascinating in the field of environmental law, and particularly looking at the Endangered Species Act, because we have all kinds of terms like determining whether a species is endangered in a significant portion of its range. What does significant mean? And agencies have had their own definitions that have been struck down, even under the deferential Chevron review. Now it's up to courts to decide what the best reading is. And in fact, there are cases ongoing, including one I'm working on right now, where we're trying to figure that out. So it's an evolving role, but ultimately the courts are, enforcing the specific requirements of the law, and then also making sure that agencies aren't taking actions that are arbitrary and capricious, which would violate the Administrative Procedure Act.
Last kind of fun question for both of you. What is your favorite or maybe the coolest animal that you've been able to advocate for during your career?
I can go for I really hate to pick favorites. But one that I think is incredibly cool is called the Eastern Hellbender. Not only is its name cool, but it is an incredibly large aquatic salamander. They can grow up to 2 feet in length. They like to live in cool, clear streams, and they breathe through these lasagna-looking folds in their skin along their sides. And so they've gotten colloquial names like Grampus, old lasagna sides. They call them snot otters because they're kind of slimy. To me, it looks like if you took a sock puppet and covered it in slime. They are just adorable in a really kind of ugly way. But they're incredibly endangered too, because water quality is declining across the eastern United States where they live. And so that's a species that my organization has been working again for years to gain protections for. And there are many biologists working on the ground to try to secure their future.
I love it.
It would be absolutely impossible to follow up that answer with anything remotely more interesting. I think I will just say that I would encourage people to remember creatures like this one that are often forgotten and are our less charismatic species. We all see a lot out there about the charismatic megafauna, right? All the big, fluffy, cute ones that rightfully so should also be protected. But I would just ask that we all remember to think about the other animals like I think chickens are adorable, right? I think possums are adorable. I think all these other creatures that most people might be like, ugh, that's not something I necessarily like would call an adorable animal. They all have their own important values and their own place in the ecosystem, and I think and the web of life, right? And I think we need to remember all of them. So I'll throw a broad like catch-all for all the less charismatic species, because I think all of our animals should be deserving of protection.
Yes, I love that and second that for sure. Well, thank you so much to both of you for sharing your animal law expertise with us today and with the larger attorney community who will be watching. And thank you, of course, for the work you do in advocating for animal protection and conservation. Thank you to all our participants for attending this presentation. We hope you enjoyed it and that it will inspire you to find ways to advocate for animals in your own practice or through pro bono advocacy. Thank you.
Thank you for joining us today. The CLE code for this clinic is 2604630N. Again, that's 2604630N. Please stay connected with Coast to Coast Legal Aid of South Florida for future programming, where we'll continue to provide practical information about the law, your rights, and the resources available in our community. Thank you again for being here. We look forward to seeing you next time.